All right. Good afternoon, everyone. Thank you so much for joining us today. We're going to get started. We are thrilled that so many of you could join us today for the English version of Preparing for Court, What to Expect in Your Child Support Case. If you are someone going through family court issues right now and you're seeking some guidance and some information, welcome. We're so glad that you're here. If you're a service provider or an advocate, or if you're just interested in learning about family law, we welcome you too. Before we start, I just want to let everyone know about our Spanish version of this same webinar next week, same time, 12 p.m. on November 6th. This webinar will be conducted entirely in Spanish. And to register, please go to familylegalcare.org/manutencion 2024. If you have Spanish-speaking clients or friends or family that would benefit from this webinar in Spanish, please encourage them to register and to come back next week. So we'll do some quick introductions first. My name is Molly Burke. I am the Associate Director of Advocacy, Policy, and Community Engagement, as well as one of our staff attorneys at Family Legal Care. Tiare?
Yes, hello, good afternoon. My name is Tiare Toribio, and I am one of the bilingual program associates on the helpline.
Thank you, Tiare. And you will also see Jessica Stadmeyer, our Director of Legal Resources and Digital Justice, messaging you in the chat or answering some of your questions. I'd like to introduce just a couple of housekeeping items before we get started. We really want this webinar to be interactive, so here are some ideas of how you can participate. If you haven't already done so, please say hello and introduce yourself in the chat. I saw some people doing that. Welcome, thank you. And throughout the presentation, we will be asking a series of poll questions. Please participate. We'd love to hear from you. We'll be saving time for questions at the end, so as we're going through the presentation, please submit any questions that you have to the Q&A button at the bottom of your screen. And then finally, feel free to send us a chat if you have any comments or concerns that come up during the webinar. And again, feel free to introduce yourself in the chat if you haven't done so already. So now our first poll. What brings you here today? Please take a moment and select the option that best represents you. A, I am a parent or caregiver. B, I am a partner or advocate at a nonprofit looking to help my clients. C, I'm a government official or staff. Or D, I am interested in learning about family law. Seeing the answers come in, and it looks like we have a really great mix of people here today. Awesome. Okay. So this webinar is designed to provide an overview on how to prepare for a child support case in the family court after you file a petition. I'm going to talk about Family Legal Care's programs and services, including how to reach us if you or your clients need any support. I will also give a very brief introduction to child support before turning it over to Tiare, who's going to speak about preparing for court, where we'll take a look at a summons and petition before diving into gathering evidence for your case. Next, I will go over going to court, either virtually or in person, as well as what to expect on the first court date and what to expect throughout your child support proceeding. Finally, Tiare will go over what to do with a final order of support and how to file an objection. Now, as we are discussing these topics, I just want to note that all of the material covered today is intended to be legal information only and not advice. As I mentioned earlier, we encourage you to submit your questions using the Q&A feature below, but you may hear us to tell you to contact our helpline or to speak to an attorney for more specific legal advice, and that's because every situation is different, and what applies to one person may not apply to everyone. So first, if you're not familiar with Family Legal Care, if you're not familiar with us, formerly known as LIFT, we were started in 1996 when a group of three young lawyers recognized the need for people to get accessible legal information. And they set up a card table in Manhattan Family Court to answer questions and offer guidance to anyone who needed help. Over 25 years later, family legal care has really grown, but our mission remains the same, to increase access to justice for families in New York Family Court. Now, each year there are over 200,000 filings, and about 80 to 85% of litigants do not have legal representation. Family Legal Care is the only organization of its kind providing legal information and support to unrepresented litigants in family court. Today, we do this by offering parents and caregivers free legal information and advice, resources, and technology to help them navigate the family court system. We don't provide direct representation, but instead we focus on promoting self-advocacy and empowerment of our participants using a limited scope representation model. And we provide these services across all 5 boroughs of New York City, as well as throughout New York State, and even outside of New York State, so long as someone has a case or an issue in New York Family Court. Our helpline gives information about New York family law and family court procedure by phone, live chat, and email. Our helpline is an entryway into our services. If someone's interested in meeting with an attorney, which I'll discuss in just a moment, our helpline associates will conduct a screening to see if the person is eligible for a consultation, and we'll go ahead and schedule that appointment right over the phone. I will say, though, that often people find that after speaking with our helpline, they get the information that they need to figure out their next steps. Our helpline associates are amazing and can give people a wealth of information or point them in the right direction. Our general helpline hours are Monday through Friday from 9 a.m. to 5 p.m., though we close for lunch from 1 to 2 p.m. The phone number for the helpline is listed here on this slide, 212-343-1122, and you can also access our helpline on our website. And we'll put this information in the chat as well. Our legal advice consultations, Family Legal Care offers, like I mentioned, limited scope representation. And what this means is that we have a team of staff and pro bono attorneys who meet with unrepresented parents and caregivers for 1 hour consultations, either by phone or by video through Microsoft Teams. And unrepresented means that they don't already have an attorney representing them in their case. The level of support that the attorneys provide during these consultations depends on the case and the litigant's needs. And now, when I say litigant, I'm referring to is someone who has a case in court. Now, some examples of what our attorneys can do include providing legal guidance on next steps, helping litigants prepare and file petitions or motions, and advising litigants on how to effectively represent themselves in court. Depending on the case and the litigant's needs, our attorneys may be able to provide follow-up consultations and follow-up support as well. If you or someone you know is interested in a consultation, you can visit our website to learn more or reach out directly to our helpline. Family Legal Care recently launched a digital justice initiative to address gaps in the family court's online resources. At our legal information and technology hubs, litigants can access technology and receive assistance to attend virtual family court hearings, download and submit family court forms, and navigate the online court system while getting in-person legal information and resources at the New York City family courts. Currently, we have 3 technology and information hubs open and located in Brooklyn, Queens, and the Bronx at the addresses that you see here. Just a quick note that the Brooklyn Tech Hub is currently open by appointment only, but the Queens and the Bronx Tech Hubs allow both appointments and walk-ins. To make an appointment, you can send an email to techhub@familylegalcare.org or call 646-496-0046. And just a quick note that you can go to any legal information or technology hub that's convenient for you, whether or not you have a case in that county. So let's talk a little bit about how you can qualify for our services. We have no income requirement for any of our services. All of our services are free. The only requirements that we have are that you are not already represented by an attorney, that the case is in New York Family Court, and that the type of case you have is one that's listed on this slide. So paternity and parentage, child support, and some and custody and visitation and some guardianship cases. Just a quick note that we do not provide advice on orders of protection. However, we can provide advice on how an order of protection may impact one of the other types of cases listed here. We do not provide legal consultations on divorce cases, as those are heard in Supreme Court, not in family court. And we do not provide legal consultations on abuse or neglect proceedings. There's generally a right to an attorney in abuse and neglect proceedings. However, we may be able to provide legal information on these types of cases or refer you to another organization who specializes in these areas. Now, you'll see some of our tools highlighted throughout the webinar, but I'd like to go over just a few of them now. Family Legal Care offers over 60 original legal resource guides, which provide step-by-step information on a range of New York family law topics. These guides are available in 9 different languages and can be found on our website at the URL you see here, familylegalcare.org/guide. Like I mentioned, we'll be showcasing some of our legal resource guides or LRGs throughout the webinar and how you can use them to help you prepare for your case. You can find all of our LRGs on our website at familylegalcare.org/guide. And then our digital justice initiative is made up of 3 main tools: the Family Law Navigator, our guided court forms, and our informational videos. First, our Family Law Navigator is an online tool that gives parents and caregivers a helpful starting point to begin addressing their family law issue. Through this tool, users can either get general information on a particular family law topic, such as custody, or they can answer questions about their own situation and in turn receive a detailed, customized report with next steps that they can take and links to relevant forms and petitions. Second, our guided court forms help litigants complete various family court petitions and forms by guiding them through each question in simple, easy to understand language. After answering all the questions, litigants receive completed forms that are ready to be downloaded and filed with the court. And finally, our Family Law Explained videos, which we will be releasing later this fall, will be short animated videos that explain family law concepts in plain language. All of these tools were designed to be accessible using any device, whether it's a computer, a smartphone, or a tablet. And you can find all of our tools on our website, so we encourage you to go check them out. So now before we get into preparing for court, we wanted to give you a very brief introduction into child support. We have additional webinars that talk more in depth about child support and how it's calculated, as well as how to file for child support. But this section is designed to give you a basic understanding of what child support is before talking about preparing for your child support case. And remember that to start a case for child support, you have to file an initial petition. You can file that through OCSS, the Office of Child Support Services, online or in person in the family court. But you should check with your specific family court or look at our LRG, our legal resource guide, for more information on how to file. Additionally, after you file your petition, you'll have to serve the other party, or if you are the other party in the case, the respondent, you must make sure that you are served properly with the court papers, and we'll touch upon this a little bit later. So, what is child support? Child support is the financial support that's provided by the non-custodial parent, or NCP, the parent who does not have physical custody of the parent with that the child does not live with, to the custodial parent or caregiver, the parent or caregiver who the child lives with the majority of the time. Now, sometimes child support is provided to the Department of Social Services, or DSS, and this happens when a child is receiving public assistance, such as cash assistance, and is listed on a budget letter. In this case, DSS, the Department of Social Services, are the ones to file, and they're the ones who are receiving the child support, not the custodial caregiver. This is a very common misconception. Child support has the general child support amount that covers expenses like food, shelter, and clothing for the child, and it also includes add-on expenses that can be either mandatory or discretionary. Mandatory add-ons are ones that must be included, such as healthcare and health insurance, whereas childcare would be a discretionary add-on and ultimately decided by the support magistrate. So now I'm going to turn it over to Tiare to talk about preparing for court.
Thank you so much, Molly. All right, so before we go into our next slide, we do have another poll for you all. Um, all right, it is a true or false. A summons must be issued by a court. So A for true, just a few moments there. All right, so for those that chose choice A, um, you are correct. So a summons must be sent by a court. A summons is a document issued by a court that informs someone that they are required to appear in court. When preparing for a child support case, it's very important to understand the paperwork that you filed or the paperwork that was served on you. If you are the person who filed the child support case, then you are the petitioner. Okay. And as you can see in our example, that the Commissioner of Social Services is also listed. So if your child is on public assistance, you will see the Commissioner of Social Services as as the petitioner um, in the summons, and you will also see the assigner, who is the person who put the child on their public assistance case and has therefore or is therefore receiving public assistance for that child. Um, and again, as you can see, the Commissioner of Social Services, and then we also have James Smith, who is listed as our petitioner. Now, if you are the person who was served with the court papers, then you are the respondent. And as you can see here in our example, we have John Smith listed as our respondent. Okay. Also, the summons will also list who will be the support magistrate assigned to your case. And support magistrate is a jurist or a person who will hear or listen to the case and make an order of child support. Summons will also tell you when your court date is, what time, and what courtroom you need to appear in. The summons will also tell you the support magistrate you will be appearing before and the location of the court. The summons will also tell you the purpose or meaning, the type of hearing that will be held. It would also tell you whether to appear virtual or in person. And just some quick tips for that. Um, you can highlight the address, date or time, and magistrate's name and courtroom, as well as if you are not available also to appear on the date listed on the summons, you can submit a written request for an adjournment, which is asking the court for a new court date. To do this, you can reach out to the family court where your case is being heard. Generally, the family court will send over a form to fill out requesting this adjournment. However, this is a request and not guaranteed. Your request will be decided on the original court date. You can also gather documentation showing why you're not available on that date provided on your summons, and the magistrate can either grant your request for a new date or proceed without you. Okay. And again, as you can see in our example, which is highlighted there, if you have to appear uh, virtually, it will list the number in which you can call in and also a link to log in virtually. Okay. Okay, and our next slide, talking a little bit about understanding the petition. So on the petition, it will say support petition. You can highlight or make note of your file number or docket number. Um, please read the petition in its entirety. So the petition will state how paternity has been established, and paternity must first be established before child support can be determined. Right? And as you can see here in our example, Molly has highlighted for us. Oh, sorry, Molly. Okay. File number and docket number. So going into our next slide, just discuss how parentage is established. Okay, so generally speaking, when a child is born, the birth mother is automatically the legal parent of that child. However, the parentage of another person, for example, the father, can only be established in one of several ways. And today I will go over three of those with you. One way is by proving that the parents were married when the child was born. If you can prove that, then both spouses are automatically deemed the parents of the child. This is called the marital presumption of legitimacy. Establishing parentage this way does not need to be done in court. It can be established simply by proving that the child was born during the marriage. Second way of establishing parentage is by proving that the parents signed a document called the acknowledgement of parentage. So this document is a standard form that states who are the parents of the child. It must be signed by the parents after the child is born and meet certain requirements. Establishing parentage with this document also does not need to be done in court. It can be established simply by producing the signed acknowledgement of parentage. And a third way of establishing parentage is through what's called an order of filiation. So this is a court order entered by the court declaring that someone is the parent of a child. The court can enter this order when the parties consent, meaning that they agree, or if they do not consent. The court can order a DNA test. Please note that the court will only consider a DNA test that is court ordered. So it will not consider an out of court DNA test. And also, in addition to these three methods, there is an important legal principle, which is known as equitable estoppel, that I would like to highlight a little bit for you. Um, and this is most common, often occurs when a biological or adoptive parent allows another person who is not biologically related to the child to have a parent-child relationship for a certain period of time, in which case the biological parent is stopped from denying that the other person is a parent. Okay. So once parentage is established, both parents have the same rights and responsibilities over the child. This is, of course, unless there is an order regarding custody or visitation, which may alter or divide the rights between both parents. Okay, so now we'll talk about preparing documents that you may need for your case. you. So here you can see a list of documents that you may need to bring with you or submit to the court for your case. Your summons, as well as the financial disclosure affirmation, or FDA, that I'm about to go over in a little bit, will also have a list of documents to bring with you to court. Also, our child support basics legal resource guides, or LRGs, also has a great list to refer to when you are preparing for your court case. Um, if you are currently not working or working on occasion, you can bring with you a job search diary and or an odd job diary showing where you have done odd jobs or where you are looking for work. Also, where you have applied to, when, and the contact person at that job. Okay, so this is an example of our financial disclosure affirmation. Now I'm going to discuss about this. So this document will be included in your court papers with the summons and the petition. There is a short form, which is what we're showing here, and a long form version of the FDA. If a support magistrate requires a long form FDA, they will let you know and provide you with that specific form. It is important to read the financial disclosure affidavit completely and understand what it is asking for. The FDA is divided into several sections: employment and income information, deductions from income, health insurance, expenses, liability loans, and debts. You should refer to your pay stub, tax returns, and other financial documents to help you fill out the FDA. Even if you are unemployed, you still need to fill out this document for court as stated on the first page of the FDA. Also, bring all supporting documentation of the information that you have provided. Again, such as your tax returns, W-2s, health insurance information, and pay stubs. Remember also, if you're receiving Social Security benefits, you can bring your award letter from Social Security with you to court and fill in the appropriate part of the financial disclosure affidavit regarding your benefits. If you receive workman's comp or unemployment benefits, you can also bring these documents to court with you. Also, a suggestion, just make sure you bring copies of all documents that you bring to court, including the financial disclosure affidavit, because any document you give to the support magistrate will go in your court file and will not be returned to you. So the other party as well, the respondent, will also need to be given a copy. So it's generally good to bring 3 copies with you to court: one for the support magistrate, one for the other party, and one for you to keep. So as you can see here, this is an example from our legal resource guides that we have on our website about filling out a financial disclosure affidavit. So it walks you step by step through filling out the FDA. It has a side-by-side comparison to your FDA that was provided to you. And then also there may be some questions that they may answer for you. All right. And then also this is our guided court forms, which assists with generating the short form FDA. So our guided court forms walks you through question by question, and you can input your information Once you answer all the questions, our guided court form will generate a completed FDA in Word or PDF format that you can submit to the court for your case. And I am going to turn it back to Molly.
Thank you so much, Tiare. So now that everyone understands the different forms, the summons, the petition that you've gathered and submitted your evidence, let's talk about going to court either in person or virtually. And let's talk about each of these in a little bit more detail. So first, family court in-person hearings. You'll want to get to the courthouse early. There could be lines to get into the courthouse. You'll have to go through security and you will need to find where your courtroom is. So it's a good idea to get there pretty early. You want to make sure you have all of your forms and documents completed. Like Tiare mentioned, it's generally a good idea to make and bring 3 copies of any evidence or documents that you've prepared with you. Like Tiare mentioned, one to give to the support magistrate, one to give to the other party or the other side, and one to keep for yourself to refer to. It's a good idea to bring a copy of your summons with you. You can refer to your summons to verify what courtroom your case is in, like you saw previously that TRA went over. When you are outside of the courtroom or court part, you'll want to check in with the court part or the court officer on the floor. And a general tip, it's always helpful to bring a pen and a notebook to be able to write down any notes or questions that you may have. And then virtual hearings. Make sure that you're alone in a quiet space. If you're in New York City and you need somewhere to go for your virtual hearing, you can use our legal information and technology hubs. If you're anywhere in New York State, including in New York City, and you don't have anywhere to go, you can also contact the family court and they will set you up with a space for your hearing to attend. It's a good idea to check your internet connection earlier that day and you want to log in early. If you're even 1 minute late, your case could be dismissed or the support magistrate could make a decision without you there. You want to make sure you have submitted all of your documents ahead of your court date. And again, have a copy of your summons with you. Like TRA showed, this will have the Microsoft Teams link to log into your hearing, and it will also have the phone number to call into if you have any issues with logging into the Teams link. Also remember that even though you're appearing virtually and you may be appearing from your living room, you're still in court. So now let's talk about that first court date in some more detail. If you are the petitioner, you filed your petition and served the other party. If you're the respondent, you should have been served with a copy of the summons and the petition and are showing up to respond to the papers. This first court date is often called the return of process date, court date. What this means is that the jurist is going to see what was filed, make sure that service was done properly, and appoint attorneys or give people an opportunity to adjourn or postpone their court date to consult with or hire an attorney for their case. Now, keep in mind that there are generally no court-appointed lawyers for child support cases unless you are the respondent in a violation case facing incarceration for non-payment of arrears or unpaid child support. Now, if service was done properly and everyone agrees to proceed pro se or without an attorney, the support magistrate will then confirm that parentage has been established legally, like Tiare explained earlier. So, in our example with Jane and John Smith, Jane, as our petitioner or the person who filed against John for child support, would have to have John served with a copy of the summons and the petition. On the first court date, their support magistrate would make sure that John was served properly and see if either party would like a chance to adjourn or postpone the court date to speak with or hire an attorney. If both parties, Jane and John, agreed to appear pro se, representing themselves, then the support magistrate would then make sure that parentage was established. Now, we saw that Jane checked off that John had signed the acknowledgement of parentage, that AOP, so the support magistrate would need a copy of that AOP, the acknowledgement of parentage, confirming that John signed the AOP and that parentage was established legally. Now, all of these steps may take more than one court date. So, for example, if someone would like to consult an attorney or if service was not done properly, then the support magistrate may adjourn the case to give parties time to either serve or consult with an attorney. Only after all of these things have been checked off can the support magistrate even begin to discuss your child support case. So again, once all of these steps have been checked off, service was done properly, attorneys were consulted, hired, or the parties agree to represent themselves, and parentage was established, then the support magistrate can issue or put in place a temporary order of support. And what this is a child support order that lasts until the next court date. The support magistrate generally has to have enough information regarding the parties' incomes before entering this temporary order. And they may ask either party or both parties about their income and expenses to try to enter that temporary order of support. Both parties have the right to call witnesses, to enter evidence on the record, which means in front of the court, in front of the magistrate. This is known as a trial, which is called a fact finding in family court. This will likely not occur on the first court date, but sometimes it can. For example, sometimes the support magistrate may discuss the FDA or any evidence that was submitted and what additional evidence is needed. Now, in our example, you can see in the top right corner, you in our example, it says temporary order of support. So with Jane and John Smith, you can see that John Smith, as the respondent, is ordered to pay $83 weekly towards the basic payment and $31 weekly towards child care. You can also see that these payments will go through SCU, the New York City Office of Child Support Services. So now to our third and last poll. True or false? You are allowed to file an objection to a temporary order of support. Is that true or false? We'll give it just a minute. I see a lot of answers coming in. Again, true or false? You are allowed to file an objection to a temporary order of support. Okay, so for those of you who said false, you are correct. You generally cannot file an objection on a temporary order of support. You can only file an objection on a final order of support. And we'll discuss objections and final orders in a little bit. But first, let's talk about how a support magistrate calculates the child support order. So let's look a little bit behind the scenes into how that support magistrate is going to calculate the child support order for Jane and John Smith. So generally, the court will base child support on a formula that uses the party's actual income. But this only happens if two conditions are met, which is that the parties, one, appear in the case, that they show up to court either in person or virtually, depending on how the court is hearing the case, on time, and that they're seen by the magistrate. And then the second condition is that the parties present credible or believable evidence about their income. So, meaning you have to provide your FDA, pay stubs, bank account statements, and all of that evidence that Tiare went over earlier. Now, the child support obligation will be retroactive or go back to the date that the parent filed the support petition or when the child went on public assistance. This means that the amount that the court determines is owed for child support can be owed for each month since the petition was filed or that the child went on public assistance. That amount will be added as a lump sum to the child support order, which can often be paid off little by little over time. Usually, you can get a credit for any amounts that you voluntarily paid to the custodial parent or caregiver between the time that the petition is filed and when you get the final order. Now, that credit can lower the or will lower the amount that you owe in retroactive support. You'll want to be sure that you have evidence of payments to get that credit. So the support magistrate generally uses a formula from the Child Support Standards Act, or the CSSA, to apply a percentage to the party's total income based on the number of children they have. So in our example with Jane and John, they have one child together, so the support magistrate will apply the 17% to their adjusted gross income, or AGI, to determine the basic child support amount. And like we talked about in the beginning, there's that child support basic amount as well as add-on amounts. But if you have more questions about how child support is calculated, I encourage you to watch our additional webinars that focus on how it's calculated, or reach out to us through our helpline for some more information, or take a look through our legal resource guides as well. And now I am going to pass it back over to Tiare to talk about final orders and objections.
Thank you, Molly. All right. Okay. So, final order, like Molly mentioned, is the supports magistrate decision on your case. They enter it or issue it after the last court date, and all evidence was presented or considered. The final order is typically mailed to you, but you may want to double check with the court about how you will receive your court order. The court will also generally send it over to the Office of Child Support Services, or OCSS, if you are paying through OCSS, or the Office of Child Support Services. However, if you want to make sure that they got a copy, OCSS, you can contact them directly to provide them a copy of your order. Um, you can see the retroactive support amount, the basic amount, and any add-ons, and how it is supposed to be paid on the final order of support. The final order will generally say order of support in the upper right-hand corner where Molly is pointing to. Now, in our example, with Jane and John, you can see this is a final order of support as it's listed in the top right corner, and that John is ordered to pay $83 weekly as the basic payment through the Support Collections Unit, SCU, and $31 towards child care expenses. You can see that Jane's responsibility for unreimbursed health related costs is 61% of the costs, where John's is 39%. And that John is to pay Jane directly for those costs, not through the Support Collections Unit. Lastly, you can also see that John has $9,234 in retroactive support that will be paid off over time. A final order of child support must always come with a findings of fact. A findings of fact is a written statement by the support magistrate about why they came to the decision that they did, and about the facts that he or she thought were important and true when they made the decision. You can see in our example here with John and Jane, it says findings of fact. In the upper right-hand corner, again, where Molly is pointing, of the first page, and it starts to explain what evidence was submitted. So, for example, we see petitioners, meaning Jane, FDA, pay stubs, and federal and state income tax returns were submitted. And a finding of fact can be multiple pages. So be sure to read very thoroughly all of those pages. Okay. Now, filing an objection. So if you disagree with your final child support order, you have the right to object. So this means you can ask the court to look at the facts of your case again. This is called filing an objection. So either party in a child support case is allowed to object. In order to object, you need a copy of the signed child support order. You also need a copy of the findings of fact. If you do not have these items or documents, you can go to the record room in the court where the order was made and request these copies. Um, and also, you must file your objection within 30 days of the decision or 35 days of the decision if it was mailed to you. Also, something to remember, you must serve a copy of your objections to the other party in your case. You can serve the objections in person or through mail. Just make sure to have the person whoever served the papers sign the affirmation of service. So, the affirmation of service, proof that the other party was served. And for more information on how to serve court papers, we do welcome you to check our legal resource guides on serving of court papers, or you can also call our helpline as well. Um, if you are served with an objection and you disagree with it, you can file a rebuttal. A rebuttal is a response to an objection. So after you file your objection, you will get a letter from the court with the judge's decision on your objection. And to close it off, Molly.
Thank you so much, Tiare. So, sorry, there we go. Okay, so today we talked about family legal care and how to get in touch with us if you need additional help after the webinar. Once again, our helpline number is 212-343-1122, and the number is posted in the chat. We went over the basics of child support, what it is, and the add-on expenses, mandatory and discretionary, as well as some of the most frequently asked questions. We talked about preparing for court, understanding what a summons and a petition is. Then we talked about the importance of gathering evidence and what the court requires you to show for your child support case before discussing going to court either in person or virtually, and how a support magistrate makes a decision in a child support case. Finally, we talked about final orders of support and what to do with them if you disagree with them by filing an objection or a rebuttal. And now we've saved some time for questions, and I believe that I have seen a lot of questions come up in the chat, which is great. Just a reminder to put your questions in the Q&A feature at the bottom of the page. That's how we will be answering some of the questions. So, Tiare, do we have
Yeah,
some
we do.
questions?
We have 7 here. Let me
Awesome.
see. Yes. Okay, so I'm gonna read it here. So, if the child lives with me since he's been born, father does visit when he feels like it, never takes him overnight or for a weekend, but I do not have a custody order or visitation order. And the judge said, come back after custody. Dad filed custody papers after child support and now wants physical custody and asked the judge if I can pay him for child support.
Interesting. So, what I would say is I hate to say that it depends on the situation. Generally, whoever has physical custody, whoever the child primarily lives with, can file for child support against the other parent, the non-custodial parent. Um, and the non-custodial parent will be responsible for paying that child support to the custodial parent or caregiver. Now, this may depend on the situation. Things can change, things can shift. That's when a modification may be appropriate, filing a modification to the original order if you have one. But for specific help on your circumstance, I would encourage you to call our helpline or to reach out to us through one of our legal information and technology hubs if you're available as well. Send us an email or live chat, and we can help you more specifically.
All right. I have another one here. Do you need to disclose Social Security?
If you're receiving Social Security benefits, generally you have to disclose any and all proof of your income and expenses. So if it's listed on the financial disclosure affirmation, you generally have to disclose it. That is a required document that the court needs to see to make the decision for child support.
I have another one here. I don't know. Okay. Can you please explain equitable estoppel again?
Absolutely. It's one of the, I would say, most challenging and confusing legal principles. So, equitable estoppel, how I explain it is when you're establishing parentage, it's something that can prevent someone from challenging parentage. So this can depend on the age of the child or and the relationship between the adult and the child. So the court is really looking at the relationship between that child and that adult. If they are holding themselves out as a parent, meaning they could be buying them birthday presents, holiday presents. They're taking them to the soccer games. This person is the child calls this person mom or dad. Then they could be prevented from challenging parentage later on.
All right. Sorry, I'm getting more questions as we go.
That's great.
Um, all right. How does child support work if he is already paying for another child?
Ah, that's a really good question. Um, so it depends on whether or not that is a if that is being paid through a court order or if it's being paid directly. The court can consider that when they're determining income for this child. So generally, child support is determined in a first come, first served fashion. So if there's a previous child support order, then the court will deduct that order, what someone is paying to that order, for calculating someone's total income in child support. But they'll need proof of that.
Um, okay. So if a child is not born yet, can a mother file for child support? For example, the father is refusing to accept the child.
Yeah, good question. So yes and no. You can file, but parentage needs to be established first. Like you mentioned earlier, Tiare, parentage will need to be legally established first. So that happens in one of several ways. But if parentage is established, you can file for child support. You can also file for child support before a child is born, but generally, child support will not start until a child is born.
All right. And okay, good question. Can an acknowledgement of paternity be signed anytime, or does it have to be around the time that the child was born?
Yeah,
Was
great
born?
question. Yeah,
Mhm.
it can be signed anytime. It doesn't have to be when a child is born.
Trying to see. Um, would someone properly serve me for child support?
I'm sorry, could you repeat that for me one more time?
So, how would someone properly serve me for child support?
Really good question. Service can also be really tricky. Generally, for child support cases, you need to be personally served, meaning that someone who is not the petitioner needs to physically, and they have to be over 18 years old, needs to physically hand you a copy of the summons and the petition or the notice to appear in the case. If you don't take them, they can leave them, the person who's serving you can leave them in your vicinity, so near your feet, near a table nearby, something like that. Once that happens, the person who served you, who gave you those papers, will fill out that affirmation of service and tell the support magistrate or the jurist, the person who's overseeing the case, how they served you, a description of what you look like, and they will hand it in to the jurist. If you disagree or if there's any issues with service, you believe that you are not served properly, you can challenge that and it can lead to what's known as a traverse hearing.
Yep. Time for another one.
One more question.
Okay. So I'm on disability. I get 1,600 that goes to the custodial parent each month. This is somehow not counted in child support. She is taking me for more support.
I always mix it up between SSD and SSI, which can be counted or garnished rather for in terms of child support. It's, I believe that it's both can be considered as income when determining child support, but only one can be garnished for child support. But call our helpline for some more specific information on that because I always mix them up. All right. So I am going to pause the questions there. Before we go, one more reminder, don't forget, next week we are hosting this same webinar in Spanish. If you have clients, friends, or family members that would benefit from having this webinar, please encourage them to register and join us next week. You can register at familylegalcare.org/manutencion 2024, and we look forward to seeing you there. It's November 6th at 12 p.m. And thank you so much, everyone. That is the end of our webinar. Before we go, we just wanted to give everyone a reminder of how you can get in touch with us, whether you have follow-up questions from today's presentation, if we weren't able to get to your question today, or you need some support or assistance with your family court case, or you just want to learn more about what we do. You can reach out to our helpline by phone, live chat, or email. The number again for our helpline is 212-343-1122, and our website is familylegalcare.org, so you can see all of our great tools like our legal resource guides and the guided court forms on our website there. And then please follow us on social media to keep up to date with things that we are doing like webinars. And finally, we would love to hear from you and get some feedback on today's webinar. As an incentive for completing our feedback form, familylegalcare.org/feedback, we will send you copies of the slides from today's presentation. Again, the feedback form is listed here, familylegalcare.org/feedback, and we're going to link it in the chat. So thank you so much again, everyone, and we hope to see you all again soon.